A lot of the videos that I put out towards the beginning of the week, whether they're Monday or Tuesday, they just don't enjoy the same size audience as the videos that I put out on Thursdays and Saturdays. So I've decided to try to take this opportunity to experiment a little bit with the content, and I've started a new segment that I'm going to do every week, if you guys support it, called The Rebuttal. Let's talk about it. What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. In a legal proceeding, as I'm sure you're aware, you have, opening arguments, you have direct examination, you have everybody's favorite, which is cross-examination, which all the discomfort happens and, you really like catch your prey in the snare, right? And then you have closing arguments. But what you might not know is that the party that carries the burden in the case gets one last bite at the apple, and that's called a rebuttal. But here's the kicker. The rebuttal is limited only to what the opposing side brought up in their closing arguments or the way that they closed out the case. So in a criminal case, rebuttals generally belong solely to the state because the state has the burden of proving the case beyond a reasonable doubt. In a civil case, the rebuttal generally belongs to the plaintiff because the plaintiff has the burden of proving their case. But we're going to break the rules a little bit because, as you know, because you're my audience, I'm a defense attorney. But also because you're my audience, I always have the burden of proving that my analysis is reasonable, of proving my case and persuading you so that you'll be able to see things the way that I see them. That's my job on YouTube. And that's generally the way that I carry myself when I'm trying to allow whoever the audience is to see things from my client's point of view as their attorney. And since I always end my videos with a closing argument, I thought it might be fun to start a weekly segment that somewhat looks like a Q&A from last week's videos or last week's topics. And I thought it might be fun to use it as an opportunity to touch on some of the stuff that was brought up in the comment section, but that I just didn't get to include in the video prior to publishing it. Now, as you might remember in some of my closings, I've mentioned this before that I've started doing this over on Substack and writing companion blogs. So if you're interested in like a deeper dive on some of these subjects, you can still go over to Substack and check it out, and I'll give you more direction on that towards the end of the video. But for this series, I'm just going to pick a few topics that came up in the comments, and I'm going to hit the highlights to try to clarify some of the issues that I thought maybe could use a little bit more light shed on them. And the videos in this series are going to be somewhere between 8 and 12 minutes. So if at the beginning of the week you don't have the 30 minutes you might have at the end of the week to sit down and watch one of my videos, you'll be able to kind of recap on what you missed or what got brought up, or maybe something that wasn't part of what you were thinking about in the previous week's videos. Moving forward, though, I'd like to invite you to send me some direct emails or maybe comment and pose some questions to me in the comment section or via email that you'd like to see on an upcoming episode of The Rebuttal. Now, remember, the rebuttal is limited to the stuff that was brought up after the video was published. So if you haven't actually watched the videos I'm talking about, each of the long form full videos will be linked in the description. So that way you'll be able to pause this, go watch the video, and then come back and pick up where you left off. So with that, let's just clear up a few things from last week in this week's rebuttal. So first things first, you may or may not know that I posted my analysis on the now internet famous Rhode Island Assistant Attorney General Devin Flanagan and her friend Veronica, otherwise known to the 15,000 people who actually watched my video, Devin and Veronica, or Rhode Island's least favorite drunk women. So you may not even know that I made the video, and so you may not know that I took it down. I did a community post and kind of explained, but in the video, I made a bunch of mistakes. For one, I alleged that Flanagan, that would be the one who's the Assistant Attorney General, had been charged with criminal trespass, disorderly conduct, and resisting arrest. And I went on to analyze all of the different ways that she was wrongfully treated, how she probably had some 1983 claims because of all that stuff, and how she was technically in public when she was on the sidewalk because she was already outside when the police arrived, and that she should have been released on a summons for the trespass and not physically arrested because it wouldn't be appropriate to arrest somebody physically for an offense that didn't occur in the officer's presence. And I was wrong about a lot of it. The first issue was that in my apparent laziness in doing research about this case, I relied on a poor source of information, and my commenters actually helped me understand that the restaurant in question had privately negotiated with the city in order to have the sidewalk there as part of their restaurants. If you look at the video, you can see tables and that kind of thing. So she actually wasn't in public. She was still in part of their private establishment, which rendered most of my analysis about the public versus private aspect completely invalid. So she was still trespassing when the officers arrived. So technically, if they wanted to take her in physical custody, they could have without violating her rights. The second issue with my analysis was that she was not actually even charged with disorderly conduct or resisting arrest. It was actually her friend who was charged with those things. And so I went into this long analysis about being charged with that and how it could violate her rights, but she wasn't actually charged with it. So it just didn't make any sense and it was wrong. And then the third issue was that she actually was released on a summons eventually. It just wasn't included in the body cam that was released. And so literally the entire analysis was pretty much incorrect. And within a couple hours, only like 15,000 people had seen it, partially because it was released at the beginning of the week. And I thought, well, that's 15,000 too many people to have incorrect information because of me. And so I just decided that that was a good opportunity to pull the plug. Not that many people had seen it relative to my other videos. And the fewer people I could keep from being misinformed because of me, the better. So that's the deal on the AG video. I'm never going to double down on being wrong. If I need to do a whole correction video, I'll do a whole correction video. I'm not attached emotionally to being correct unless it's in the context of making sure that I get it right. I want to get it right because it's my responsibility to be honest. If I need to pull a video and lose the 6 to 8 hours worth of work I put into it, so be it. I guess I should have put the extra time in to make sure that I was verifying the information and that I was correct from the beginning. So I hope you'll forgive me for that. All right. Up next is the James Freeman arrest. Many people got upset at me over my analysis of this James Freeman arrest, and I feel like a few things need to be addressed about that video. First and foremost, as I mentioned in the video, I had actually never spoken to James, either text or call or anything, but he actually got my number and texted me right after the video dropped, and he personally thanked me for giving an honest and objective analysis and for saying the hard things that people don't want to hear, whether people wanted to accept it or not. We had a nice long conversation over the phone the next day, and I'm confident we'll have many more in the future. I liked him. I think we think similarly. I think he's a genuinely nice guy, and I think the only thing he really cares about is making the country a better place for the average American citizen. But something James said sort of struck me as profound, and I hadn't really considered wording it in the way that he articulated. And what he said, not verbatim, is that people will defend him regardless of what he does. And that's really not any different than people defending the police, regardless of what they do. Those people were generally referred to as bootlickers. And the point he was trying to make is like licking his boots is the same as licking the cops' boots. At its core, it's a blind loyalty to something based solely on what the thing is. And he wanted an honest breakdown of the legalities, not blind loyalty. And so he was thankful that I said what I said because he felt like I was being honest. And I was thankful that he saw it from that perspective and found value in my analysis. But another thing that I noticed as it relates to that video is that it seemed like people were confused about what I was actually trying to analyze and accomplish in the first place with the video. And that's my fault. I should have made it clear what I was trying to do. So many of the commenters in this space on YouTube are sort of like all or nothing people. And that's basically bootlicking by any other name. It's nothing in the law is all or nothing. Everything in the law is gray. Nothing's black or white. That's part of the problem with police officers because they think in terms of black and white, but every part of their job is gray. If you truly want to understand the law, you have to be willing to allow some legal nuance into your mind. You have to be willing to tell that tiny anarchist in your heart to shut up for a minute and let you at least try to absorb useful information that can help you be a critical thinker. Labeling everything that you don't want to hear as copsplaining is really only guaranteeing that you're tuning out the information and that you cannot learn from it. My intent with analyzing the Freeman video was to take a deep dive on whether the chief would be charged with a crime. That was it. That was what my audience was asking me about. Did you see this assault on James Freeman? Did you see this attack on James Freeman? So my job was to try to analyze that like a prosecutor would, to try to figure out whether the legal elements of a crime could be met, even from like a probable cause standpoint, because you have to remember that probable cause, each element of the crime has to be met on the basis of probabilities too before you ever get to probable cause. So I wasn't making the argument that what they did to Freeman or what they did to the Aikens was right. I wasn't making the argument that they weren't playing dirty or anything to that effect. But so many of the commenters basically said that if I wasn't going to call out every single foul ball they hit, then I was for them and I was against Freeman. And I just don't see the world that way. And if you do, you're never going to be pleased with what I have to say, because every situation changes based on the facts. And the only thing I care about is the truth. All factual information is valuable. The second that you choose to ignore factual information because it doesn't fit your worldview, you're losing. End of discussion. Now, the most significant thing that I think the audience got confused about is the civil remedies versus civil rights argument that I was trying to explain in the Freeman video. And the most simple way that I can kind of lay it out is when the state charges a person, they're seeking criminal remedies, they're charging a crime, and they're seeking punishment. When a plaintiff files a lawsuit, they have, the rules of civil procedure, and they're using those rules of civil procedure to try to seek civil remedies like temporary injunctions or injunctive relief or money damages. Civil rights are another category, and those, as you know, are guaranteed by the Constitution. And they are different than what the Aikens were trying to accomplish with this deposition and with this entire scenario. So many of the commenters got hung up conflating, Freeman's foot on the door with a cop's foot unauthorized on your door holding it open. And it's actually a good parallel to draw, but the main difference is who holds the privilege to exclude the people. In your home, you could make the argument that you have a right to physically close the door. And if that means closing the officer's foot in the door, so be it. Will there be a consequence for you trying to do that? Yeah, most of the time. Most of the time, you're going to get arrested for trying to do that. And depending on the state and the circumstances, you may well get convicted. You could also be exonerated and have the charges dismissed. And the only way to figure out which is going to happen, who's right and who's wrong, is to litigate it. So either you go through the criminal process and you beat the charge, or maybe they get dismissed voluntarily and you file a lawsuit, or maybe you file a lawsuit after the charges are gone. But in the Freeman video, what some of the commenters overlooked was that this was not a public part of the building where Freeman was just trying to exercise his First Amendment right, same as he would like in a lobby. This was intentionally moved by the city in order to circumvent First Amendment protections. And in this scenario, the agents of the city hold the privilege to exclude Freeman from that room, and to do so without him being able to claim First Amendment retaliation for his inability to record. Again, he was there to record on behalf of the Aikens for a private deposition while seeking civil remedies. It had nothing to do with his First Amendment right. So in order to prove a crime, the evidence would have to show that Chief Noland had a specific mental state where he intended to either insult, provoke, or injure James Freeman by using unreasonable force to remove him from having his foot on the door. And my only point was that it was such a controlled takedown and minimal in its impact with the ground and the way that he moved Freeman away from the door that I don't believe that the evidence available to us at the time lended itself to being able to prove that he had anything in his mind other than he was following a command issued by the city attorney to exclude James Freeman from the area that they were trying to make a secured area. Now, yes, it's true that the lawyer blocked the doorway and all that stuff. None of that was what I was trying to explain. I certainly believe all of the things you guys believe. They were wrong. They were playing dirty, all of that. But so many of the commenters are constantly pissed because they think I should just come on here and talk about how people should act. He was right and he was wrong. That's not the purpose or the mission of my channel. Yes, I talk about what's legally right and legally wrong, but that's not my opinion. That's based on the law and the legal framework and the jurisprudence of the state that I'm talking about. I'm not qualified to determine what your value system should be, and that is a two-way street. No one gets to tell me what I should believe either. I'm not here to virtue signal or preach or point you in the direction of my moral compass. If that's what you're looking for, you're in the wrong place because I'm not ever going to do it. Last but not least, the Burger King caper. I had a lot of fun talking about the great Burger King brunch investigation, but I had a bunch of people who basically told me I was talking too much during the interview because they saw it as same as like when I brought Jeff Gray or Lackluster on for a podcast. But that's not the purpose of what I was trying to do with Mark Vermillion. Look, if you think I talk too much, you're probably right. But I'd rather have 100,000 people who actually value what I have to say than to try to appeal to millions and millions of people who are looking for a free, by the way, custom YouTube experience. I'm not interested in customizing my commentary for you or anybody else. Just go find someone who entertains you exactly the way you want it. Maybe you'll be able to find somebody at the Burger King in Haledon, New Jersey. See what I did there? Because so many of the Yankees in the comments dinged me for saying Haledon. I thought that's what the officer said when he said, "Do you come all the way to Haledon to get breakfast?" I was just trying to say it the way I thought he said it. It wasn't that I was incapable of saying hail. Even though, in the South, that's hail no. But there you go, guys. I am capable of Yankee speak. It's Haledon, New Jersey. I hope you're happy. Anyway, what was actually happening in that interaction between Mark Vermillion and I was that he and I had already gone over his story before I started recording. And what I was trying to do was to let you guys have sort of a fly on the wall view of what it looks like to get a legal consult. And I was actually giving him a legal consult on what I thought this interaction presented as far as legal issues that he could potentially attack, strategies he could use in cross-examination, that kind of thing. And I was trying to do that in a way that it could happen at the same time that you guys are watching it unfold so that you wouldn't have to sit through the interview with him plus a secondary legal analysis. That's what I thought was the most considerate thing to do, and the thing that was shortening it to an hour instead of making it an hour and a half or two. So for that, I apologize. But honestly, I'm not here to entertain people. I'm here to try to teach people who, first and foremost, don't think they already know everything, and two, who are critical thinkers who are willing to take the time. If that ain't you, fine. It doesn't bother me a bit. But, I don't know how to do this any other way than talking for however long it takes to make the point I'm trying to make. All right. That about does it for the first episode of The Rebuttal. I hope you guys like this format. It's fun for me to recap. So I'd like to make this sort of a weekly way that I can interact with you guys that is not so involved as to be like a normal video. Now, again, if you'd like to have a deeper dive, I'd like to invite you over to Substack. That's a newsletter site where I'll sometimes write a companion blog to try to lay out some of the issues that I didn't think of at the time the video was made. It's absolutely free to join, though you can join on a paid tier if you want to. I don't put anything on Substack that people have to pay for. That's only there for people who want to support the channel monetarily. If you don't want to go to Substack, but you'd like to support monetarily, I'll leave my Venmo and PayPal links both here on the screen as well as in the description. Please remember to like and subscribe and leave a comment on the video. Check out some of the other videos on the channel and leave a comment on there as well. Again, the full-length videos of each of the issues that I discussed in this episode will be in the description. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.